Hello everybody. Today I am here to discuss about the recent judgment that was delivered by Honorable Supreme Court of India pertaining to Vinita Sharma versus Rakesh Sharma case. This judgment was delivered on 11th August 2020, and this judgment gives us a clear picture about the co-parental rights of a daughter in our country. Previously, we had lots of confusion pertaining to the rights of a daughter as a co-partner in the ancestral properties, as well as the properties that are self-acquired by the father. But this judgment have cleared all the doubts pertaining to the co-partner rights of a daughter in the Indian society. Before discussing about this judgment, it is mandatory that we have to discuss about two things. One is Hindu Succession Act 1956 and the other is 2005 amendment in Hindu Succession Act. Now let us understand who all covers under Hindu Succession Act. Hindus, Buddhists, Jains and Sikhs. These are the four categories of the people covers under Hindu Succession Act. This act discusses about two types of properties. One is ancestral property and the other is self-acquired property. Ancestral property is nothing but the property that you have acquired from your fathers and great-grandfathers. And self-acquired property is nothing but the property that you have acquired by your own, that is from your earnings. The property that you have purchased from your earnings is called as self-acquired property. So this is the difference between ancestral property and self-acquired property. According to Hindu Succession Act 1956, the properties and the rights on the properties were reserved only to male co-partners. Now let us say what is co-partner. That is the three descendants, in the sense son, grandson and the great-grandson, that is the three generations of a person are called as co-partners of that particular person. So these three generations are the co-partners of the family, that is from the same bloodline, and in addition to this, only the male descendants are reserved with the rights to acquire the property, and the female has got no right on the property. For example, if a person dies, his son, his grandson and his great-grandson has got all the rights on the property, but whereas the widow, that is his wife or his daughters, have got no rights on the property of that person. And in case if the person has ancestral property, he has got no right to write a will deed also, allocating the property to his family members. And in the same way, in case he has got self-acquired property on his name, then he has got all the rights to allocate his property as per his will and wish to his family members, including his wife and daughters. So this is the biggest drawback in Hindu Succession Act 1956. And this has faced lots of criticism in the public also, that no rights are reserved for female, that is daughters as well as wife. And this being the course, Amendment 2005 in Hindu Succession Act has come into force. And this particular amendment speaks about testimonial succession and intestate succession. Now, what is testimonial succession and what is intestate succession? Testimonial succession is nothing but the succession that is acquired through a will deed. And if a person executes a will deed before his death and allocates the property, that is his self-acquired property, to his family members, then it is called as testimonial succession. In the sense, he have declared that his part and parcel of the properties should be allocated to his respective family members in a ratio, and the ratio is also being decided by that particular person who is executing the will deed. So this is called as testimonial succession. And now coming to intestate succession. What is called as intestate succession? Intestate succession is nothing but if a person dies without executing a will deed, then this comes under intestate succession. So in these circumstances, this amendment clearly says that in the ancestral property as well as the self-acquired property, the daughter has got equal rights as the son. In the sense, if a person is deceased, as per this particular amendment, the widow wife, the daughter as well as the son has got the equal rights on the properties of that particular person who is deceased, intestate. And the other major change that has occurred through this amendment 2005 is Section 6 abrogation. Section 6 of Hindu Succession Act 1956 speaks about survivorship rule. Survivorship rule is nothing but the rule that says that only the male descendants of the same bloodline has got the rights on the properties. And this was abrogated through this amendment, that is Amendment 2005 of Hindu Succession Act 1956. And now there arose a great confusion through this amendment. That is, this particular amendment was brought into force on 9/9/2005. So the date has given a great confusion in the public, in the legal sectors as well as the common public. The question arose whether the rights of a daughter can be claimed in case if the father is dead before 2005, or is it mandatory that the father should be alive at the date of amendment, in the sense at the date of this act coming into force. This was the biggest confusion in the common public as well as in the legal sectors, and this has become a question of law. This being the situation, in the year 2016, Supreme Court has delivered a judgment in Prakash versus Phulvati's case, where it has declared that it is mandatory that the father as well as the daughter should be alive on the date of amendment coming on force, that is 9/9/2005. So this has given a clear picture that it is mandatory that a father and the daughter who is claiming the right on the property should be alive on that particular date of the amendment coming on force. And then in 2018, in the case that is Dhanamma versus Amar, Supreme Court has again given a contrary judgment, which is again a dual bench, in which it has declared that even if the father is dead in the year 2001, the daughter of such father has got all the rights to claim the equal rights in the property, and she would be called as a co-partner. So this was the other conflict judgment that was issued by the Supreme Court. And now to clear the confusions of the previous judgments, Supreme Court has issued a new judgment in 3-bench court, that is Vinita Sharma versus Rakesh Sharma. In this judgment, it has declared that a daughter has got reserved co-partnery rights from the birth, and she can claim her rights as a daughter in the properties, an equal share as that of a son, immaterial to when the father is dead. In the sense, for example, if a daughter wants to claim the right on the property, that is equal rights on the property, and if the father is dead in 1990 or 1992 or 1995, whatever the time it is, she has got all the rights as a co-partner to claim equal rights in the property that is ancestral and self-acquired of the father in case if it is intestate. Of course, for ancestral property there is no right for the father to write a will deed, but whereas coming to the self-acquired property, they has got all the rights to claim the equal rights in the property. Hope this video is clear to you and this would clear the confusions pertaining to the new judgment that was issued by Supreme Court. Thank you.